May proceed when ready.
May it please the court. My name is Matthew Grossman. I'm an assistant public defender with the Brunswick Judicial Circuit, and I represent the appellant in today's case, Jerry Downey. I'd first like to start off with a brief recitation of the facts. On April 10th, 2008, an individual by the name of Rasheed Norris got into an altercation with Mario McNeil. Ms. Norris was pregnant at the time. In this physical altercation, Mr. McNeil kicked her in the stomach. Rasheed Norris's sister then telephoned Mr. Downey, the appellant in this case, that was their cousin, and told him about this altercation. Upon finding out about this altercation, Mr. Downey reached out to a friend of his, Mr. Browder, as well as some other individuals in the local town, told them about this altercation, and they decided then to proceed to Glenville. Mr. Downey was driving one vehicle with Mr. Browder in the passenger seat. The rest of the individuals were in another vehicle. Upon arriving to Glenville, Mr. Downey and Mr. Browder, the co-defendant in this case, saw a group of individuals who had learned they were coming about this altercation. These individuals approached the vehicle with sticks, with bats, and throwing things. At that point, Mr. Browder reached out from the passenger side window and over the vehicle and fired shots from a handgun that he brought with him. And his testimony was that that was to scare away the individuals who had come at the vehicle. Once the scene cleared, Ms. Galloway, the alleged victim in this case, had been struck with a bullet, and she would die some days later. The appellant, Mr. Downey, was convicted of 6 counts being a party to the crime, those 6 counts being murder, felony murder, 3 counts of aggravated assault, and a possession of a firearm during the commission of a felony. He was sentenced to life plus 5 years. Without waiving the enumerations of error set forth in appellant's brief, there are 3 enumerations that I'd like to focus on today. Those enumerations are listed in appellant's brief as enumerations 2, 3, and 4. The enumerations 2 and 3 deal with juror Dasher. Enumeration 4 listed in appellant's brief are the argument that the evidence was insufficient to convict the appellant Downey as a party to a crime. Starting first with the issue with juror Dasher. And enumeration 2, as it's listed in the appellant's brief, is that appellant's constitutional right to a fair and impartial jury and right to due process were violated when juror Wayne Dasher misrepresented his testimony during the voir dire process. We understand that the two-pronged test is to show that the juror wasn't truthful during voir dire and that would have given rise to a challenge for cause. Juror Dasher's misrepresentation comes about when he was asked about his employment status. He testified during voir dire that he was employed as a banker, which was a half-truth. Juror Dasher was also a board member with the Department of Corrections and was compensated through the Department of Corrections. He did not reveal that during the voir dire process, and defense counsel was unaware of that during the selection of the jury.
Does the Department of Corrections pay the board members? I wasn't aware of that.
This specific juror Dasher was compensated a few $1,000s, enough so for appellant to argue that that was part of his employment. He received compensation. This was not a volunteer situation.
Is that a stipend or is it like salary?
I believe it was classified as a salary in this context, but I'm not 100% positive as to
it's a few $1,000s.
Yes, that's correct.
And is it clear that's not just a per diem or some sort of reimbursement of expenses?
My understanding is that juror Dasher was not a reimbursement, but it was compensation for his time to serve on the board with the Department of Corrections. And had he given that response, it would have led to further inquiring about his status with the Department of Corrections, which would have opened the door to the fact that not only was he a board member with the Department of Corrections, but he was also an honorary life member of the Georgia Sheriff's Association, an honorary Georgia State Patrol officer. And while we understand and we concede appellee's argument that just by being a board member with the Department of Corrections that wouldn't have given per se rise to challenge him for cause, the argument from appellant is that the fact that he misrepresented this information was intentional. That seems to be the only logical implication of him not revealing that information is he knew that by revealing that, he would have likely opened himself up to at least a preemptory strike, if not that of a challenge for cause. So it's our position that that intentional withholding of information shows in his inherent bias, which would have led to an argument that would have prevailed that he should have been challenged for cause. that he was so biased and so eager to get on this jury, and that's evident by the fact that he would misrepresent what his employment status was, especially in light of the fact that the alleged victim in this case, Ms. Galloway, her mother was employed through the Department of Corrections.
Is the fact that he was paid, is that part of the record?
He was not called during the motion for new trial, but that leads into the second enumeration of
I
it.
mean, it's not part of the record?
No, Your Honor. It was put forth in the motion for new trial, but it wasn't entered into evidence because there was no way to authenticate it. But that goes into, and that would backtrack to a possible inadequacy of counsel argument that was not further explored with Juror Dasher. But it also goes into what's listed as the third enumeration of error in appellant's brief, and that's that appellant's entitled to reversal because the trial was tainted by an appearance of impropriety and the prosecutor's failure to disclose and the judge's failure to disclose that they knew Juror Dasher and knew his connection to the Department of Corrections, and that is a part of the record. The principle of due process extends to require prosecuting attorneys to disclose evidence to the accused which is both material and may affect the outcome of the trial, and that goes into the jury selection process.
Do you have any evidence that that goes beyond material and exculpatory is a Brady term, which normally goes to guilt, innocence, or sentencing, not everything related to a case?
And I agree with that, Your Honor. But in this context, it's an unusual situation where Mr. Skeens served on the Rotary Club both before the trial and after the trial with Juror Dasher and knew information that was relevant to defense counsel.
So the judge is supposed, and the DA are supposed to affirmatively do defense counsel's job and tell them you may be missing all these facts that may or may not be relevant?
Well, the argument is in this context where both the prosecutor and the judge know that someone has misrepresented information and has not been completely forthcoming. It would be one thing for the prosecutor to give tips to opposing counsel of questions they should be asking. But in this context, both the prosecutor and the judge knew that he served on the Department of Corrections.
Did the defense lawyer ask any questions in voir dire like, do you have any relationships with people in law enforcement or in prisons?
No, and that would then fall back to an enumeration of error that was put forth in appellant's brief as to inadequacy of counsel. That should have been, especially in light of the alleged victim, in this case his mother, working for the Department of Corrections, should have been a question that was asked. But it's
Counsel, what exactly is the evidence that is in the record that Mr. Dasher was in fact employed by the Board of Corrections?
The evidence that was in the record, the evidence that was put forth during the motion for new trial was taken, there were newspaper articles from the local county that identified Juror Dasher and his connection with the the Georgia Department of Corrections, as well as...
Is there no hearsay objection to newspaper articles coming in?
There was, but the issue was it was at a motion for new trial where Juror Dasher wasn't called, but the judge during that motion for new trial acknowledged that he knew Juror Dasher and knew him well enough to be able to put on the record as to his character and had known him for a long period of time. But should this court be more inclined to find that the evidence wasn't properly preserved at trial, and especially the questions weren't asked during the voir dire process, we would argue that that would be inadequacy of counsel.
The problem there is if you raise it as ineffective assistance of counsel, then you had an obligation at the motion for new trial hearing to create a record of ineffectiveness. It sounds like there's absolutely nothing in the record actually admitted into evidence that shows that Mr. Dasher was in fact employed by the Department of Corrections.
Well, I would disagree with that in the notion that the judge does acknowledge Juror Dasher and acknowledge his knowledge of who he was and his relationship with the Department of Corrections.
Well, relationship, I serve on boards, but I'm not employed by the boards. So people who know me might say, I know of your relationship with X, Y, or Z board. That doesn't make me employed by that board.
And I understand that, but the argument in this context is, especially in light of the prosecutor and the judge knowing who Juror Dasher was, that they had a duty to disclose that and disclose that they knew Juror Dasher was not being completely forthcoming. The last enumeration of error that I want to touch on today is the argument that there was insufficient evidence to convict Appellant Downey as a party to a crime, especially in light of this court's findings and holdings in Browder v. State, which was argued 2 years ago, and the opinion was rendered 2 years ago, 294 GA 188. That was the case involving the co-defendant, where this court upheld the conviction but found there was no specific intent but instead implied malice. So part of appellant's argument is that the shared intent necessary for a party to a crime would be inapplicable here, where there is a finding of only implied malice or a reckless disregard for human life. There was also enumeration put forth in appellant's brief that there wasn't a shared intent argument, and in this context it would appear the jury, in light of the Browder decision, would have had to find Mr. Downey to have a higher intent level than that of his party, the actual principal in this case. There's also the sufficiency of the evidence argument, and I want to point out two cases that were brought up by appellee in their brief, and also bring out a case that I think is more analogous with this case that was cited in those cases. The first being Morris v. State 276 GA App 775. That case is inapplicable here because those co-defendants were convicted of involuntary manslaughter. And the facts are also very different in that case. In that case, the party to the crime assisted the accomplice in actually pursuing the vehicle where the alleged victim was and was yelling at the victim the entire time when the incident occurred, when the shooting occurred. The other case of Teasley v. State, 288 GA 468, that was a conviction for murder on the basis of the parties to the crime. But in that case, there was the party to the crime actually participated in the fight. That fact is absent here. And the brother willingly stayed there. They drove them to the scene. They actually participated in the fight, and they threatened to kill the individual who would later end up dead. And that's an important distinction because that shows that shared intent for the outcome that would occur. The case that's far more on point would be Brown v. State, which is 250 GA 862. It's a 1983 case where this court found there was insufficient evidence to find somebody guilty on murder as a party to the crime. And in that case, this court went to say there was no direct evidence of any kind that he intended the outcome which occurred. Appellant would argue those are the facts in this case.
Is that your best authority that you're arguing Brown?
Yes, Your Honor. In Brown, the court argued the mere fact that he participated, and this is a very important distinguishing factor. In Brown, the party actually brought the shotgun, brought the weapon, he brought the ammunition, he had pointed the gun at the alleged victim at a certain point, and still this court found there was insufficient evidence to show that there was a conviction because the altercation and all of those things that were pointed out does not constructively supply any intent to shoot the alleged victim. In this case, Mr. Downey did not bring the gun. Mr. Downey did not bring the ammunition. The only evidence that would point towards any knowledge of that would be there were statements offered into the record where Mr. Downey looks to Mr. Browder and says, "Are you ready? Or do you have the gun ready?" And that's when the individuals were coming at the vehicle. The only thing that can logically be taken from that is that possibly he was nervous about the aggressive crowd coming at him and wanted to make sure that just in case he had the gun. That's the most, I believe, that could be read into this, especially in light of the Brown case where the ammunition and the gun was actually provided by the party, and there was still insufficient evidence because it did not show an actual intent for the desired outcome to happen. And that's the argument in this case, that there is no evidence that Mr. Downey actually desired the outcome which happened in this case, which would be the shots being fired at all, which would be the basis of the aggravated assault, as well as the end result of the murder that occurred of Miss Galloway. And then that would undermine the felony murder, as well as the possession of a firearm during the commission of a felony. So with that, the appellant Downey is entitled to have his conviction reversed, we'd argue today, because the evidence was insufficient to convict the co-defendant Browder of having the necessary intent, because this court found only implied malice, and furthermore that the evidence is insufficient just on its own to find that the appellant, Mr. Downey, had the desired outcome, shared that intent of the outcome in this case, and therefore we'd ask that his conviction be reversed on all counts. And if there are no other questions, I'd ask that my remaining time be reserved for rebuttal.
You may do so.
Thank you.
Thank you. Ms. Dutton?
Thank you.
May it please the court, Sandra Dutton for the State of Georgia Atlantic Judicial Circuit. Your Honors, I'd like to give you a little background information in this case, which really explains a lot of what happened, which is the real crux of this case occurred in the transcript around page 343 to 354, and that was the charge conference. This was never a case about who done it. Everybody knew who done it. There was a whole street full of people who saw who done it. They knew Melvin Browder shot that gun. Melvin Browder told them where to find the gun in the pond. The gun was recovered. Melvin Browder took the stand. He said he did it. This case was always about getting lesser included charges. In the pretrial motions conference and hearing that they had prior to this trial, the defense attorneys put the plea offer on the record, and that plea offer was for either felony murder or malice murder. Take your pick. Life. That was the offer. And they had to go to trial because the judge really can't pontificate on what the jury charges are going to be until after all the evidence is in. So they had to get to that point where all the evidence was in before they could get to whether or not they would get these lesser included. The involuntary manslaughter was argued, the reckless conduct, pages 343 to 48, voluntary manslaughter, pages 350 to 353. Now, the judge did give an instruction on accident, but both trial attorneys, actually all three, but in this particular transcript, Cox and Joseph testified that the short voir dire was trial strategy for them. That's 69 where Cox did it and 99 where Joseph did it. The reason it was short voir dire is this trial was not about who did it. It was like, would they get those lesser included charges? And I would like to point out, although we didn't, the appellate didn't discuss the Batson charge, it was actually, the judge gave them 10 jury strikes. I got that wrong in my brief. I think everybody said 9, but the judge did give them 10. That's in the jury selection transcript on page 7. But if you understand what was going on with them trying to get these lesser included, even in that motion hearing, the one of the attorneys says, I want to object. I don't want the medical examiner to say the manner of death was homicide. Don't want him to say that word, because obviously he was after manslaughter. So then moving down to Wayne Dasher. First of all, Wayne Dasher was truthful. The judge said in answer simply and directly. He gave how he made his living. He made his living as a banker. There's nothing in the record that would show his bias. In fact, he was asked approximately 6 times whether or not he had bias. All these jurors were. The judge gave an overview. He says, you're going to be asked about bias. Then they heard the statutory voir dire, and that centers around whether or not your mind is perfectly impartial between the state and the accused, whether you have any bias whatsoever. There's 2 or 3 questions there. Then Joe Skeens, the prosecutor, stood up. His whole thrust was, do you have bias? He did it at the beginning of his voir dire, he did it at the end, and his voir dire was very brief as well. And then the defense attorneys also hit on it. He was asked numerous times. Wayne Dasher had no bias to declare. Now, the appellant has said he was eager to get on the jury, but that's not so. At one point, when he heard there was a man named Dasher who was going to be on the jury, he raised his hand and said, I might be kin to them. I don't know. But he was a Dasher. This witness was a Dasher, and it turned out that they were not related. In fact, the witness was a person of color, and Wayne Dasher is white. He was trying to conscientiously answer those questions. And many of the jurors said they were self-employed but didn't tell what they were self-employed in, and the judge said, if you're self-employed, tell. And they're not being accused of lying or withholding information or trying to be anxious to get on the jury. And furthermore, in light of what the defense attorneys were trying to accomplish through getting these lesser included, Wayne Dasher, if what they say about Wayne Dasher is true, would have been the ideal juror to have had on that panel. This was a case involving the brutal murder of an 18-year-old girl just a few weeks before her high school graduation. It was the kind of crime that would really upset a community. And if you wanted a jury to consider the nuances between reckless conduct and voluntary manslaughter and involuntary manslaughter, you would need someone who could think outside the box, someone who would not be guided by blind emotion, someone who would really be willing to grapple with the different facts of these different lesser included. I submit to you that a jury like Wayne Dasher would have been ideal. And to your honors, you're very correct in asking questions by saying, is this in the record? No, Wayne Dasher's what he does and his so-called ties and what he does on the Department of Corrections is not properly in the record. In fact, the appellant tried to get the judge to take judicial notice, and he wouldn't. And he tried to get the prosecutor to stipulate to certain things, and he wouldn't. Please don't believe they were being coy. I've known Wayne Dasher since we were in first grade together. I didn't know he was a banker. I thought he was an onion farmer. I'm glad I wasn't asked to stipulate to anything. It's very dangerous to ask for the judge or for the prosecutor to stipulate things that they've just heard. And the things that Judge Cavender allowed into the, he said you can go ahead and tender those into the record, but I'm not accepting them as evidence. And it was things off the internet, which, hey, we know the internet's true, and out of newspapers, which are probably more reliable than the internet.
To what extent, if any, did the judge restrict voir dire?
I don't think he restricted it in any way. I'm sorry.
There were no questions asked that were objected to and objections sustained?
I don't recall. There perhaps were, but I don't recall anything. But Wayne Dasher was never asked about fraternal relationships or about board memberships. And we don't have in the record how many times the Board of Corrections or Department of Corrections, how many times that board met, whether or not that money was a stipend or per diem, we don't know. It's not properly in the record, and we don't even know what their duties are on the Board of Corrections, or I personally don't. Perhaps you do. But if Wayne Dasher had been subpoenaed to come to that hearing, he could have cleared up a lot of these facts and we would have had competent evidence. But instead, the appellant is relying on basically speculation and innuendo, saying that he's biased. But the crucial issue here is there bias? That's going by Miller v. State. The crucial question is bias. He was asked numerous times. He had no bias to declare. He answered truthfully and honestly. He told how he made his living. He made it as a banker. And all of the other people who were questioned gave one answer, except for one who said, oh, and I'm a recording artist too. But everybody else stated one thing, and certainly there were people on this jury who had incomes other than that main job that they said. Perhaps, well, I won't even speculate, but certainly out of this many people, they would have had more than the income, the primary source of income that they named. So, Your Honors, it's the position of the state that Wayne Dasher was not biased in any way, and that had these attorneys gotten the lesser included charges that they wanted, he would have been the ideal person on that jury to have thoughtfully considered the nuances of these lesser included charges. Moving on to the fact that the judge and the prosecutor did not disclose their relationships. When the jury pool was asked, how many of you know Joe Skeens, numerous hands went up. And it was kind of a laughable moment because Joe Skeens in the outset on page 27 talks about how he's a lifelong resident of Tattnall County. And so obviously many people in that pool knew about him. And I suppose this court can take notice of Judge Cavender's very long tenure with the court and in that circuit. And of course, there were many relationships.
Let me ask you about the Batson issue, the state had, what, 9 or 10 strikes, is that correct?
There were 10 strikes,
10
Your Honor.
strikes, and it didn't use 6 of them, but 3 of the 4 strikes it used were against people of color.
That's correct.
What was the reason for that?
Well, he was never asked, and they didn't make an issue of it at the trial. And in fact, in the motion for new trial, both Attorney Cox and Joseph said that Batson was not an issue with them. The reason they didn't think that color or race made any difference in this case is because the victim was black, and everybody involved in the street that night, the shooters and the people with the sticks and bats, they were black as well. They just didn't think there was any overriding racial issue in this case. In fact, Your Honor, I would submit that striking some of the black jurors may have actually been helpful to the other side, because I'm sure Ebony Galloway's death was keenly felt in the entire community, but among the people where you would expect, where she grew up, the yard she played in, the community she lived in, it would have probably most keenly affected the people of color in that community.
Surely you aren't saying that the state struck those jurors to help the defense, are you?
No, Your Honor, I'm not at all. I'm just saying that they're claiming racial reasons, and I'm saying, again, they have a presumption. I think that they were struck probably for very valid reasons. I don't know what those reasons are. Joe Skeens was never asked those reasons, and so there's not anything in the record that would show that a Batson challenge could have survived. But I'm just saying that in a case like this, race was really not an issue, and this was a case where the death of a young girl was very keenly felt in the community. But no, I don't think he struck them at all. I think he has some good, valid reasons. He's also, not only is he a lifelong resident and a prosecutor for a very long time, I think it's also in the record that he's the solicitor. So he had a lot of local knowledge of things that were not even brought up in voir dire. Your Honors, moving on now to the whether or not they should have disclosed their relationships in a community like that, it really would be impractical, because there were so many interrelationships between all these people in the pool and the judge and the prosecutor, and it makes perfect sense that is why it's up to the attorneys to propound the questions during voir dire. In terms of Browder not being able to be found as having shared the intent of Browder, the appellant has suggested that Downey would have to have even a higher intent than Browder, and I suggest that yes, he did. He actually did. He was the one that gathered up the people. He got the gang together. They were in 2 cars to show, in a show of force. He also bought the gas for both cars. He also said, "Do you have the gun ready?" He also was the driver of the lead car. He was also the one that stopped in the street on the 3rd pass-through. He actually stopped. And then he sped away after the shots were fired. McNeil's said that they cursed and then they drove away. And so he was the driver of the getaway car. And the appellant has suggested that, oh, those shots were fired because they felt threatened. If they felt threatened, all that Downey had to do was drive away. He was the captain of that ship. He didn't even have to stop, but he stopped in a situation, and it gave Browder the opportunity to shoot the gun, and he did. And the evidence was that McNeil was coming towards him. Now, Mario McNeil was the person who purportedly kicked the girl in the stomach, but it was Alan Michael McNeil that was approaching the car with Ebony, his girlfriend, close behind him, trying to get him to keep him from approaching that car. And then Megan, her best friend, was behind her again, trying to get Alan Michael from approaching that car, and when the shots were fired, it was towards Alan Michael. The recklessness in this case was the fact that Browder was a bad shot, and the bullet hit Ebony Galloway. I don't think anybody ever intended Ebony Galloway to get shot. It's it's sort of reminiscent of the Cash case, which this court just published yesterday, because there was an unintended victim in that case, and there was transferred intent. And I don't think anybody, Browder, certainly he got on the stand and he said he didn't mean to kill Ebony, and I'm sure he didn't, but it was McNeil who was being the threat, and it was a McNeil who had kicked the girl in the stomach. And this case, the Browder case is very much like another case, Color v. State, 277 Georgia 717. It's a 2004 case in which some people decided that they would go get retribution for a murder that had occurred, or for a killing that had occurred. I don't know whether it was a murder, but for a killing. And they went, and several men went and shot up a house. Well, they wounded the man that they had wanted to get, but they actually killed somebody else who was in the house. And this court said at that time that the appellants did not act with criminal negligence, that they intentionally fired bullets into a house occupied by three people. The primary objective was to kill Mills. There was a great likelihood of violent harm, and there was an unintended victim. And in this case, Browder intentionally fired bullets into a crowd. The primary objective, or Downey's primary objective, was retribution because his cousin had gotten kicked. There was a likelihood of violent harm, and there was an unintended victim. The appellant cites in its brief Price v. State, and it says a co-defendant can be found guilty if the co-defendant has knowledge of the intended crime and shared in the criminal intent of the principal. I submit to you that Jerry Downey is the principal in this case. He didn't shoot the gun, but he was the principal. Browder would have never been on the scene had it not been for Jerry Downey recruiting him to do it. Jerry Downey's malicious intent for retribution came to fruition on the streets of Glenville when Ebony was killed. Of course, I'm sure he would have liked it much better if McNeil had been killed, but instead it was Ebony, and I don't think anybody wanted that. But it was Jerry Downey who is the one who gathered up the gang, who put the gas in the cars, who asked if the gun was ready, who stopped the car in the street, did not drive off, and gave Browder the opportunity to shoot. Certainly, he shares in the intent in this crime, and the trial court should be affirmed, and these convictions should stand. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor. I would argue, on appellee arguing that it would be impractical to reveal the relationships in the jury selection process, that a appellant or defendant in this case's due process rights aren't shelved just because it's a small town, just because those relationships are well known to individuals. The argument that it's impractical, I'd argue that it's necessary to ensure the voir dire process is upheld and that a defendant is given the proper, fair, and impartial jury that he is entitled to. Going to the sufficiency of evidence argument, appellee argues that appellant Downey did have the higher criminal intent because of the actions that he took, and I'd argue that would be impossible in this case. The only thing that the evidence shows is that the appellant did indeed call friends to then go to Glenville. He bought gas, we would concede to that. And he stopped on the street. Appellee puts forth that he could have retreated, he could have driven away, which is what he did. Appellant, there's no evidence, in fact, that he desired the shots to be fired from that gun. And once they were fired, that's when he fled and got out of what he perceived was then a dangerous situation. And I think it's important to note that the other individuals who followed in the car behind them were not charged as parties to a crime. And they would have just about as much culpability as Appellant Downey would have, and we'd argue that there isn't any culpability in that context because nobody knew that Mr. Browder was going to take the actions that he took. Just because the appellant knew that Mr. Browder had a gun, he asked him if the gun was ready, there is nothing in the evidence to suggest that the appellant knew that Mr. Browder was going to take those shots, knew that the appellant was going to take those measures aggressively against the crowd. The only thing that it suggests is possibly a fear that if they did get violent and did approach the vehicle, that he could brandish the gun in order to scare the crowd away. There is nothing in the record, and there is no evidence to put forth that Mr. Downey had the intent that that gun ever be fired, let alone that somebody died that day. And we understand the concept of transferred intent, but there's nothing in the record to show that the appellant Downey wanted anybody to be shot that day. We'd argue that Brown is controlling in this case, and as I said earlier, in that case, that individual actually brought the gun, brought the ammunition, pointed the gun at the intended victim, and still the evidence was insufficient. Here, Mr. Downey did not ever touch the gun. There was no allegations that he ever asked it be fired or even was the one who provided the gun. Therefore, we'd argue that the evidence is not sufficient for Mr. Downey's conviction, especially in light of this court's ruling in the Browder and the co-defendant's case, where only implied malice was found. Thank you.
Well, on behalf of the court, let me thank both sides for your assistance all this way up here to help us with the Skyler case, and we wish you the very safe journey home, and thank you again.